David Stotesbury has been involved in some of the most important fire law cases for the last 20 years. It's a privilege to introduce him to you. He and I have been friends for at least 20 years and have collaborated on some of these cases. The Red Lion Chambers fire law team is particularly proud that David Stotesbury continues to be closely associated with our new website and with future cases. David, you are arguably one of the most experienced fire lawyers in the country. Just tell us a little bit about your background and your history.
It's very kind of you to say that I'm one of the most experienced fire lawyers. I've been involved with fire law since the 90s, acting as head of enforcement for the London Fire Brigade and then practicing as a barrister independently. Since then, I've been fortunate enough to be involved in a range of cases and also had some input into the drafting of the fire safety order, which is now the law in relation to fire in this country.
Now, you've advised on a range of cases and you've advised across the country various fire brigades. What sort of advice work have you been doing?
Well, I'm instructed by, I think, half the fire brigades in this country, and again, I'm very fortunate in that. What I try to do is be a critical friend to all my clients, the brigades and private clients as well, and actually draw their attention to the limitations as well as the opportunities that fire law provides.
Would you agree that the practice of fire law is a fairly specialist subject and it's not a generalist area that anyone can dabble in?
Yes, I'd entirely agree with that. Fire law is a unique area of law. To understand it, one would have to bring to it a knowledge of the previous legislation, the directives, the European directives, and indeed some of the discussions in Parliament, the committees, when the order was being steered through it. So without this knowledge, there's a potential for an oversimplified approach to fire law and potentially a fatal one.
David, at what stage would you suggest that a lawyer should be involved, either when prosecution's about to start or when someone is defending in such a fire case?
I'd say at the earliest opportunity. We were involved in a case called Draper, which is a Court of Appeal case, and the instructions by the fire service at the earliest opportunity played a significant part in the eventual success in that case. Again, being instructed early in the Penhallow fire did help. Without that, I don't think there'd have been a result that was favourable to the fire service. So actually involving a specialist lawyer at the earliest opportunity is crucial to progressing the case appropriately.
David, do you find that it is necessary to train fire officers and particularly fire investigators in relation to evidence gathering and presentation?
Yes, absolutely. I've been, again, fortunate enough to be involved in the training of fire brigades, both in their individual brigades and at the Fire Service College since the 90s. And the advance that fire officers have made since those days is quite staggering. Contemporaneous notes, space interviews, a range of matters. So, again, appropriate training is critical to progressing the case appropriately.
Because presumably juries in courts or magistrates in the magistrates' court don't often see fire cases, and therefore they need as much assistance as they can get, whether from witnesses or experts.
They do indeed, and there's a tendency for certain witnesses to believe that the jargon they speak will necessarily be understood by magistrates and juries. And an important part of training is for these complex matters to be converted into plain English, so they're understood in court.
David, you've done a range of high-profile cases recently. Can you just give us a snapshot of one or two of them, please?
Well, a snapshot of three I'd mention would be a case in Wales where holiday homes were brought within the scope of the order, and there was a potential for this to go to the highest level, potentially the European Court as well, but the appellant decided against it as a result of both the presentation and the comments of the judge in the light of the presentation of the case. I think the other one I'd really mention is the Penhallow fire, the prosecution after it, where the entire hotel was burnt down with sadly a number of fatalities. And it was extremely difficult to reconstruct the hotel from scratch. computer modelling. There were no attendances at PACE interviews. The interviews had to be done by letter and information elicited by way of Article 27 of requisitions. And to get guilty pleas in important areas was very satisfying. The third one was the determination for Premier Inns and Leicester Fire and Rescue Service, which I did in conjunction with Colin Todd. And there we established that fire brigades, enforcing authorities, could not go beyond the statutory guidance provided by the Secretary of State. And it's been a salutary lesson both to fire services and to clients that the guidance is a benchmark which should be referred to and not depart from unless there are valid reasons for doing so.
David, you have a long association with members of the Red Lion Chambers Fire Law team. Can you just tell us about that association?
Yes, well, we've been associated together, you and I have been associated together for quite a long time. In fact, we did our pupillage together longer than I care to remember. But I have been associated with the Red Lion Chambers. There have been a number of junior tenants that I've asked the fire brigades to instruct, and there's been a close relationship because as far as capacity is concerned, it's very reassuring to rely on competent and effective barristers in the chambers.